other modules like this one. And B, because we only had 1 hour, the emphasis was on providing you, giving you new information, okay? What we will be doing here is different in the sense that you will have readings to prepare every week. There will be a combination between, you will always, not always, many times you will have to read something from a textbook, but then it will be scholarship and primary sources. I want to emphasize primary sources. I want us to understand how human rights work in the context of primary sources like case law, general comments by the human rights monitoring systems, UN resolutions, etc., etc. Okay, so I want us to see how this works in context and, in a sense, be in a position, bring you in a position, allow you to make your own conclusions. Okay. So this is why it is very, very important. I was not, and it is not generally speaking my character to get into and say, okay, did you do the reading? What do you think that? What is your opinion about this scholar? I don't work this way. But especially for this seminar, it is important that you're prepared, and it is important, especially when I give you case law, that we all know the facts of the case, we all know what the court said, so that we can discuss the case law. Okay? Sometimes case law comes with summaries. Okay? For instance, I gave you 3 judgments for next week. I also provided the summaries. Why I did that? A, because I want to be realistic. Some of you might not, for any reason, be fully prepared. I want you to have the minimum, knowledge so that you're in a position to contribute. And second, because it is a good starting point. Some judgments in international law, they are very long, they are very lengthy, and you are not yet experienced enough to be in a position to say, well, this is the preliminary issues, I'm not interested in that. This is what an NGO intervening said, I am not interested in that, to know where to focus. Okay? So the summary of the case, if you start by reading the summary, will allow you to see what were the facts, what was the issue, what did the court say. And then I invite you to read the whole judgment so that you can see how within that long document you need to focus. In terms of assessment, this is going to be assessed by a 5,000 word essay. Okay, I remember that in the first semester I was giving you on the discussion board some questions that most of you, or to say all of you, simply enough ignored. I'm not going to repeat the same mistake, so no discussion board. We are losing the opportunity to interact through these means. I attempted, I must tell you, because I think our relationship needs to be very honest, I attempted to make it compulsory. I attempted to make it, to give you credit, something like 20% of the final grade to be given on discussion board. For some formalities, this is not going to be applicable this year, but as of next year, this is going to be the case. So you will all have to contribute to the discussion board, but no discussion boards for this year. Two more points about the module. The first one, you must have seen that in the handbook, I recommend a textbook. Okay, there is not a huge number, but there is a number of textbooks on international human rights. It goes without saying that you're absolutely free to choose to opt for any handbook you want. The reason why I have chosen the one I have chosen, the Shooter's book, is because it addresses a number of issues which are pertinent for our seminars and which are not, you will not find them in other textbooks. I will be giving you some readings from this book, but again, you will see that this will not always be the case. So the idea is that we go beyond textbooks and we work, because this is an LLM module, with more advanced scholarship and with primary sources. Okay, so don't buy the textbook. It is available in the library. a number of copies. I think we have 6, 7 copies of the book. I'll make sure that these are there for you so that no one can take them at home. And you will see that we will need it on a few occasions, but generally speaking, there is no textbook for this module. And the very, very last point is that I have contacted 2 colleagues from the University of Manchester, and I invited them to join us at some point. So the idea, it is people who are researching on particular areas. So for instance, we have a seminar on international economic law, for instance, investment law, trade law, but mainly investment law, and the interaction with human rights. What happens when you have multinational corporations that go overseas and they pollute the environment, they break human rights, they use raw materials that are necessary for the local population. You have cases where people had to abandon their homes, etc. So there is a clash between development, economic development, and human rights. What happens in that case? That person has extensively researched on that area, so I invited him, and he accepted to contribute to that seminar. I will be here, obviously. I will give you the reading list, but he will be here to share his views and to share his research with you. And there will be another person also who is a postdoctoral researcher at the University of Manchester who will be joining us for this. I'm just awaiting confirmation from him. Are there any questions? You saw my mail yesterday. Vital, again, is not yet available. I think that they will solve this problem by some point next week. Until then, they have prepared a mailing list for me, the one I used yesterday. So until I tell you that Vital is ready, where I will start uploading all the materials we will be using, the way for us to communicate will be through emails. As I did yesterday, I gave you the reading list, I gave you the information about the room, which obviously was not accurate. Any other questions you may have on the module and how to run?
Is there going to be a practice assignment like there was with
A formative assignment? Yeah, no. Unless if you tell me that because many of you did not submit it last year, and because the purpose of the formative assignment at the LLM is to give you like a mock exercise so that you can see how you're doing. So we did that in the first semester. Did you all in the first semester visit the feedback that was available for you online?
Yeah.
Yes, all of you? You know that on Turnitin, this time I will not be marking international law on Turnitin, but for this module, in summer, you will only need to submit it on Turnitin, more environmentally friendly. And I just want to make sure that you all know how to receive comments. There are comments on the text, but then there is a screen on the right that has detailed feedback for each one of you. So did you all read this?
Yes.
Okay. So the purpose of the formative assessment was to give you feedback and to allow you to improve any kind of problems that would be detected and to prepare you for the assignments. But now you had a formative assignment, you had a number of courseworks, you will receive feedback on this, you know how to do it. It goes without saying that if at any point you tell me, something, I would like to give you, I wrote 1,000 words on this question and I want feedback, I'll be happy to do it. But no official formative assignment, no deadline, etc. Okay? Any other questions?
When are we going to know the theme of the assessment?
Okay, I don't know, because again this involves a long procedure, because centrally we have the director of the LLM who will invite us to give the coursework, then we'll have an internal scrutiny meeting so that all modules have the same level of complexity and they are clear, etc., etc. This goes to externals and they come back. It's a process. I don't know when, but if it was up to me, you would get it the latest possible. Yes, because and this is empirical observation, many students, once they have received the topic of the essay, disappear, or they don't prepare for the exams. They say, for the class, they say, well, I'm going to write on extraterritoriality. This was seminar number 3. You're now number 6. I don't care. So motivation drops like that. So in order to keep you engaged, I would give it to you, I don't know, after the break, Easter break. I know you would hate me, but yeah, hopefully you will have it before that.
The problem is everybody give the questions at the same time. And,
Yes, because this is coming centrally from the university because of the procedures I told you. So there is an internal scrutiny and then there is an external examiner. And then the university collects all the answers from the external examiners, they have a deadline, and then they are released to you. Okay? Any other questions?
Is this the first time the module is being offered at the university?
It is the very first time it is offered in this form. So there have been in the past modules on international human rights protection, but the way we'll do that now is designed by me. So it is a new module in that sense.
Why did it change it?
It was not running for a small number of years, and then because at the LLM we want this to be also research-led, okay? And this goes back to what I was telling you, that this is not a seminar that, I mean, you will need some knowledge, but then it is the idea of critically engaging with it and creating your own understanding. Which means that this requires, you know, some research background, and the idea is that each one of us has the flexibility to, in a sense, align this with his or her own research interests. Plus, as all areas, but especially human rights, is so huge. You have thousands of questions, thousands of areas, etc., thousands of subsystems of protection, not thousands, many, which means that you know, there is flexibility as to what you will do and where you will focus. And this also gives me a good pass for the next point I want to make, if you don't have any other questions. Any other questions? Okay, I had 5 questions, 4 of which were on exams, and 1 on substance. Forget the exam, forget the assessment, enjoy it. Okay, we'll have together 24 hours. We'll discuss a number of topics. Some of them are more technical, and I will explain you why. Some others are more human rights oriented, and they have to do with values and morality. That area is a combination of the two. Plus something extra, I'll come back to that point. Just enjoy it, okay? The first point I want to make is that human rights is an area that combines, to my understanding at least, 3 different areas, okay? So, international human rights protection is international law. And this is why I asked you if you've studied international law in the past. But it is also an area that originates from domestic constitutional law, so it has elements of constitutional law. If you want, it is a hybrid area that combines constitutional law and international law. Plus, another point is that human rights are, and this is something we'll discuss in more detail in a while, is not something which is objective, that we would all agree on what human rights is, what is right, what is wrong. It is very closely associated with morality, and morality might be subjective. Okay? So, morality you can associate with ethical philosophy, international law and constitutional law. For someone to be a good human rights lawyer, he or she needs to master all these 3 areas. Moral philosophy, constitutional law, human rights dimension, and international law. I'm starting with the first point, constitutional law and international law. Let's start with the basics. First of all, we're talking about human rights. What is a right?
Accept education.
Sorry,
Education.
Education. Yeah, this is an example of a human right. Okay. Plus, I would add, just to provoke you, it is doubtful what this right means. You will see why in 3 or 4 seminars. I will try to challenge that idea, that perception. Okay? But wait for a few more weeks. But my question was, what is a right? Not human right, not international human right. What is right? In a legal sense, not right or wrong, but what is a legal right?
Certain privileges that are guaranteed because of the law enforcement.
Privileges. Yeah.
It's rules for
Rules.
Regulate the society, the relations in society.
Mm-hmm. This is the purpose of the law overall. But specifically a right?
A faculty? Something that you're allowed to do?
Okay, something you're allowed to do, one dimension of a right. I am allowed to do, and you should not prevent me, you should not create obstacles if I want to do it. Yes, this is one aspect of a right. Another one?
Creates an obligation or a duty to not violate.
Mm-hmm. Duty is the corollary of a right. If I have a right, you have a duty. Let's focus on rights. Right is freedom. I'm allowed to do something. More?
Protection?
Protection goes to the idea of a duty. I am allowed to do something, or there is not so much freedom, it is another dimension of rights which is associated with protection. So protection is the duty, the corollary would be what? The opposite of protection. I protect you.
Recognition, isn't it? No, not necessarily. That's positive.
Any other ideas? Do I have the right not to do something? Is it only freedom to do? Or it can also be freedom not to do?
Yeah.
So, freedom to do or not to do something, which means I expect someone else to prevent me or allow me from doing something. Rights also are associated sometimes with entitlements. And this is more closely associated with the idea of protection. Okay? So, you have an entitlement, I need to protect you by offering you this entitlement. Welfare state. Okay? So, are rights only human rights? Can you think of rights in other areas? In law.
Aren't human rights that are essentially guaranteed to every person, so anything that's not guaranteed to everyone, like a right that's arising out of a certain contract?
This would be this is close to the definition of human rights, what you're saying.
Yes, anything that's excluded from it is a general right.
Okay, examples? I accept the definition, but that approach, but rights? You're lawyers, okay? Is there anyone who is a political scientist here or anything like that? Do you all have a legal background? Yes? So you're lawyers. Give me some rights, legal rights that are not human rights.
Civil rights?
Yes, an example?
Could it be like those that are from a contract? Like you and I can have a contract, and we create rights and duties according to that.
We make a contract, I will sell you this. Not that this is worth something, but it's my notes for today, whatever they mean. Their value may be. But I'll sell you this, this creates you the right to get this, and the duty for me to give it to you. This also creates a right for me to get the money, and the duty for you to give me, okay? A very simple example. So, human rights are about legal rights. It is an area of law concerning the human being, okay? What is human rights then? Examples are what here, like right to education.
Right to food, water.
Food, water, yes,
Life.
life, hmm?
Medicine.
Yes, medical treatment, access to drugs, yes.
To seek refuge.
Hmm?
To seek asylum.
Seek asylum, yeah. Other human rights,
Freedom, speed.
freedom of speech, not in this classroom though. Other rights,
Freedom of religion.
freedom of religion. Why do we put all these rights under a common umbrella and we call them human rights?
Because they're universal legal guarantees, and a human being is entitled to them anywhere in the world just by virtue of them being human beings as universal legal guarantees.
Universal, I like this idea, it's a bit romantic. Human rights need to be romantic, they are a romantic area. Yes, if this was a movie, I would tell you that yes, this is right, but you didn't see it from the beginning. You came into, I don't know, 1 hour late. What was at the beginning of this movie? When did human rights appear? And why we call them human rights?
Evolution,
Magna Carta.
Magna Carta, yes.
the right to develop
Right to develop what?
all personality to the fullest extent.
Yes.
So that's evolution.
Social contract.
Social contract, yes. What is a social contract?
It's a theory whereby it says that you give up certain privileges in order to get certain protection from the state. So it's basically a contract, a de facto contract with the state, whereby you gain protection.
Okay, so this is John Locke and Jean-Jacques Rousseau, the UK and France, and the idea is that we are all under the state, under the power of the state. We have an inherent freedom, which is simply not because we're human beings, and we make a contract, an unwritten one, with the state, and we say, I'm giving you my freedom, but then, so that we can live all together, otherwise it would be a jungle. On the other hand, protection, but not only protection, we will see later on what this involves. Okay? This is very close to the point I want to make, but I'll come back to that.
You talk about natural rights.
National rights. So this is very close to the point I want to make. It goes to the constitutional dimension. Before that, why we call them human rights? Why we created that area of law and we've put them all together into a basket? Why human rights are different from the right to sell or the fundamental rights of a state or the rights to when we have a contract and you do a job and I pay you for it.
Just by being human, you're deserving of those rights. Like everyone in the world doesn't know where you're from or how old you are.
Okay, again, this is a good point. We will come back to that in a while when we will be discussing the universality of human rights.
It's considered.
I keep it aside. Yeah, good point.
It's considered like natural.
Natural, the same idea. Yeah, I'm a positivist. Don't forget it when you will be writing your essay. Okay. Yeah.
The inalienable, like they cannot be taken away.
Inalienable. Oh, I like this. What is inalienable?
There's certain guarantees that apply to everyone, and it cannot be taken away. Like the right to
Okay,
life
it cannot be
everybody
taken away. Yeah, we will discuss this next week. Wait, but my reaction is because we all, as undergraduate students, sometimes even at school in some educational system, we say human rights are fundamental; they are inalienable rights because of us all being human beings, and we all love each other, and it's so nice in society, etc.
In practical.
We are lawyers. Let's give it some meaning. And in this seminar, let's try to understand what human rights is in its real dimensions. Okay? So, forget for a moment logos and slogans and why human rights is a different area than other rights. It definitely has to do with yes, protect the human being and natural, etc. Another reason,
They're common in all states. And
universality again. We will come back to that. Yes.
Focus on the individual.
The right to life, yes, it might be universal. Death penalty is not universal. Some states follow it, and this is a limitation to the right to life.
yeah.
Abortion is not universal. So I'm just preempting this discussion. I'm telling you that yes, if we want to stay in this kind of pink cloud like in Alien to human rights, yes, they are universal. We all agree. Yeah, torturing someone is wrong.
It happens anyway.
Yeah, it happens anyway, but you know, what I'm telling you is that maybe they are not as universal as we think they are. Okay? What makes human rights a distinctive area? One is they are associated with a human being and the ideas of dignity or whatever. Other idea? You're very close. You said something before.
But the natural rights.
Yes, as national law.
National, when I said natural,
Is it national or natural?
natural.
Ah, okay. I thought you said national. No. Then you go with this group of people. Discuss it later. Another common element. Rights translate into duties. Whose duties?
State.
State. Do you all agree with that? We have rights vis-a-vis whom?
The individual.
Later on, again, it is the same problem. You have watched that movie, but you entered some, with a delay. We will reach this in a few seminars, and you're right. But originally, basically, the way human rights started, it was us to be protected or to have our rights and freedoms respected by whom?
This thing.
The state. Human rights, and this explains why they are constitutional originally in their nature, have to do with the social construct. Freedom, equality, all the principles behind them, they are much more general and they apply in a variety of contexts, but in the context of human rights, they originally, now this has evolved, this has changed, but originally human rights had to do with the relationship between the state and the individual. Okay? So human rights is the state with a capital S and the individual, the human being. Why with a capital S? Even now in international law scholarship, especially French-speaking, Latin American, scholarship, etc., in all papers they write it with a capital S. Why?
Because it has personality.
It's a country.
An individual too has a personality.
Capitalised that then. Capitalised that as well.
No, but the idea is to solve the contrast. One is a state, the other is an individual. Why a state with a capital?
Because the individual is a country, like you're referring to a particular country.
So what?
It's capitalized.
No, it is not we're talking about the state in abstract, not India or, Bulgaria or... Why the state is in capital? There is a legal explanation and a sociological explanation. Legal explanation, international law, states are... What is the key principle in international law? Sovereign. So the state is sovereign. What does it mean, sovereignty? Both legally and then sociologically.
Absolute.
Absolute, yes, in a sense. Autonomy. This means I am a state, this is my territory, you are my individuals, you're under my authority. No one else can interfere with you. I'm a sovereign. You are my subjects. You're under my exclusive competence, and authority. You depend on me. I have the monopoly of force, of power. If I want, not now, go back 600 years ago. If I want, I can kill you. If I want, I can punish you. If I want, I can order you to abandon your house and go fight for me. If I want, I can try you. I can arrest you. I can enter into your house. Why? Because I'm a sovereign ruler and you're under my authority. And this goes back, so that everything makes, sense. This goes back also, if you remember, to the two theories of statehood that we discussed in this. One of it is you're recognized by your peers, legal recognition. The other one, statehood, is a fact. Why? Because you have effective governance, because you can effectively impose your authority on a territory and on the people of it, under it. Okay? So, at the beginning, at the origins of human rights do not have any kind of an international element. There is no international element in human rights. This comes centuries later on. Originally, the idea of human rights is that yes, we are under your power, but you should not abuse that power. And the idea of a constitution is that we make a contract with the state. Modern states, they are democratic, most of them, they have institutions, checks and balances, etc. But in the past, no, it was a ruler whose power was deriving from God, in brackets. So the idea is that we make a contract and you will self-limit your power over us. You will not arrest us unless it will have been tried by a court, etc., etc. You will not punish us unless, etc., etc. You will not punish us unless if there is a clear law that provides certainty and we know that doing this is wrong. Non-retroactivity, for instance. Does it make sense to you? Yes? Everyone? So, human rights originate from the interrelationship between the individual who is under the authority of the state. And constitutions, traditionally, what is the... Do you come from countries that have written constitutions? I know you don't, but written constitution, where are you from?
Latvia?
Written constitution?
No idea.
Okay.
Written.
Written constitution, yeah, it's Latin America, isn't it? Yes, of course you do.
Well, the UK.
UK, okay.
Written constitution.
Written constitution. Where are you from, by the way?
Yeah, written.
Sorry?
Written constitution.
Where are you from?
Japan.
Japan, Malaysia, China. Written constitution, yes.
Yeah, kind of.
UK,
China.
China, okay. So, what is usually traditionally constitution doing? It is doing two jobs, two works. What are these two works?
Organizing the state.
Organizing the state, it is setting the rules of the game. What are the institutions, what power each one of them will have, how you get power, how you transfer power, competencies, yes? So it is creating an overarching structure for the state to perform and
Protecting individuals.
protecting individuals. Sorry?
Fundamental rights.
Fundamental,
We call it that.
fundamental human rights. So this is one of the two functions of the Constitution. Until World War II, there was no international dimension in human rights. Human rights were in some constitutions, not many, but in some constitutions, and the idea was that this limits the power of the state. Clear? Yes? With World War II, we start internationalizing human rights. What does internationalization of human rights mean?
Creating a regime, overarching regime that covers all of these human rights that are common to most states.
What do you mean by an overarching regime?
So I think from last semester, jurisprudence and erga omnes, so certain obligations from which they can be.
Before that, again, this is the same. You've all watched the same movie, but you came half an hour late. You came something like an hour late. We will see you jus cogens and erga omnes, but we will see it later on. Before that, previously, in simple terms, what does it mean to First of all, why we internationalized human rights? We will see what internationalization means, but why we did it? Any ideas?
To ensure states protect individuals.
Yes. Why we needed it?
Because if you look at what happened in World War II, the offences that happened to people, there was no, like, I don't want to use the word universal again, but nothing that protected all humans.
Okay.
Like states weren't abiding that when they went into another country and burned them.
Okay. Yes. Good point. Both good points. Other points? Guys, wake up and speak.
Isn't it like, in a way, to establish limits to the sovereignty and the autonomy of every state in order to guarantee the protection?
Internationalization limits sovereignty, yes. Why to do it?
Because of the
In simple terms, what happened in World War II?
Wasn't it to prevent the atrocities of World War II from happening again?
This is the idea. Until World War II, this was only the domaine réservé. It is only purely a matter of domestic law. No state, so this is one state, there is another state here, which has again its own individuals. No state could knock on the door of another state and say, what are you doing there? You're violating human rights. The other state would say, well, look at your job. This is domestic law. I have never made any kind of promises to you. I have never accepted to be bound by any kind of international law, legal obligations that I will respect human rights. But most fundamentally, it is a means to apply pressure against states that did atrocities. So you have the Holocaust, you have all the atrocities of World War II, and then we said, well, this is something that it is very serious. We cannot let it continue being a matter of domestic law. We cannot accept sovereignty on that. We need to limit sovereignty. We need to take it from the domestic sphere and make it something which is international, so that it becomes an issue of international law and one state can, in a sense, control another state. Okay? Clear? How we achieve in international law the internationalization. How we take an area which is, so this was, and it continues to be, domestic law, and we grabbed it, and we created a clone which is international law. Okay? How do we do that, technically speaking? Imagine you live in World War II, you have survived the war, you're a big expert of international law, and they invite you, they tell you, you know something, we want to internationalize human rights. How will we do it?
It's structured enforcement. Like the courts, the ICC and the UN.
The ICC was created 15 years ago.
Well, before World War II was the PCIJ, wasn't it? But what it is, there's an international...
ICC or ICJ, you mean?
What I'm saying, before World War II was the PCIJ, so I'm saying there's an
Okay.
structure.
The PCIJ is a predecessor of, not the ICC, the ICJ, you meant. Okay. The ICJ is now increasingly dealing with human rights issues. For the first 30 years of its life, it was not at all working on human rights. And it is not a court, a human rights court. It is designed to solve disputes between states. As to enforcement, you will remember from the first seminar that enforcement in international law is rather problematic. Why? Because it's to a limited extent institutionalized, sanctions by the United Nations Security Council, for instance, but for the most part of it, it is an elephant versus an elephant. And it goes back to the idea of countermeasures, and if this is a small state and a big state, and political considerations, what we discussed in the first semester. So enforcement is problematic. But my question was how we internationalize it, as a matter of technicality.
By creating an international treaty? For
By
example?
creating international treaties, a good example. Other means, how do we create law? International. Treaties?
Custom.
Treaties and custom. So the idea was, after World War II, that we would take what originally was designed to be domestic law, part of national constitutions, and we will create a clone of it at the international level. How? By signing treaties and by creating international custom. Okay? I presume you all know what is custom and what is an international treaty in this room. Do you? Yes? Do you? Okay, we'll discuss it afterwards. You have a number, so after World War II they started with the Universal Declaration on Human Rights, which I have it with me, I can project it or otherwise upload it for you, okay? It is a document that creates a Bill of Rights in the framework of the United Nations, which per se does not, it never becomes international treaty, okay? It is the Universal Declaration. Do you know what its nature, legal nature is?
Soft law.
It's soft law. Have you ever heard the Universal Declaration before here? Yes? If not, just raise your hands. This is why I'm here. The Universal Declaration is a document discussed by a number of experts. Behind them, of course, you have states. In the framework of the United Nations, right after World War II. So in 1948, you have the General Assembly passing a resolution that contains a Bill of Rights. That resolution, per se, is not a treaty, is not legally binding. But it is the beginning, it is the idea. It is what cracks here the shell of domestic law. And we start pulling this up and elevating it at the international level. And after that, you have a number of international treaties at the United Nations level. The United Nations negotiate, states within the United Nations negotiate a number of international treaties, some of which we will discuss in December. Okay? Before the United Nations, you have at the regional level, for instance in 1949, right 1 year after the Universal Declaration, the same people were involved in both projects. You have in Europe the European Convention of Human Rights, which is again a very important Bill of Rights that the Honorable Prime Minister of this country wants to repeal, wants to, to let the United Kingdom outside the system. So the idea is that something which was purely domestic at the beginning is transformed into international law. Okay? How? By the means, by the tools that we traditionally have in international law, treaties and custom. Clear? The question now I have for you. This is a system that was designed, a set of laws that was designed to regulate the relationship between the subjects of the sovereign and the sovereign, the state itself, with regard an area that is very close to human nature, human dignity, fundamental rights, and all these ideas. This has been designed to function in this way. Human rights mean that I am an individual, you're a state, you don't have the right to get into my home, you don't have the right to do, or you have a duty to provide medication. Okay? That area of rights and duties is designed to perform, to produce effects within this box, within this framework, individual state. How can it work if we transform it, if we copy and paste it into another legal system which is designed to create and establish and regulate relationship between states? You see what I mean? The origins of human rights are constitutional. They have to do with the relationship between the individual and the state. international law traditionally is regulating relationship between states. How can we make these work at that level? Do you see what I mean? Do you see the question I'm raising? Do you all understand the question?
Yeah.
Yes? All? All of you? Okay. 3, 4, 5, 6, 7, 8, 9, 10. 6, the 6 of you here, and the other 7 over there, 2 groups, try to discuss that idea. What we need to change in human rights so that they become international. How we need to tweak them, how we need to adjust them so that these can work this way. 1 group, 2 groups. You are with this group. 1, 2, 3, 4, 5. Prepare here is not exhaustive because we have a topic on the internationalization of international law. But before that, just some preliminary points. So, how did international law have to change? This group first? The spokesman?
We, for example, said that international law had to change in the sense that its enforcement went into the national level, where national courts, for example, could enforce human rights obligations that were signed by states at the international level. So, if, for example, if a state was a party to the International Covenant on Economic, Social and Cultural Rights, its obligations under that treaty could be enforced at the national level.
Okay, this is a good point, very good point. I would keep it in my list. I would slightly change it. But we're here just because of my obsession to be accurate technically. International law has always been called to produce effects at the domestic level. So if one state and another state would sign that, this is my territorial waters, or this is the tax you need to pay for importing goods, this international treaty would need to become domestic law so that state organs, policemen, the navy, the tax authorities, they would apply it and they would comply with the international obligations of the state. The difference, however, with human rights is that human rights not only become part of domestic law, but they are, and this is the idea of self-executive treaties. These are treaties that can be directly invoked by individuals. Which means that you have an individual who can go before the domestic court and can say, you know something, the European Convention of Human Rights provides this. And the judge will not say, well, you don't have the right, this is international law, this is the international relations of the state. Will say, yes, these are your rights, and they are part also of domestic law. So, self-executive treaties and the idea that at the domestic level, individuals can directly rely on international law. Other points?
Did then that mean that individuals became subjects of international law?
This is the most fundamental. So, if we go back to the Spider-Man metaphor, the very first thing you observe is that you can just jump and you can throw these things. The very first, the fundamental difference, change in the DNA of international law is that international law ceases to be a system that contains only subjects, only states. International law widens so that individuals can also become subjects of that system. The rights are directly regulated by international law. And this has a huge number of very profound changes, brings impact on international law. So, individuals are subjects of international law, self-executing treaties, other ones.
We said maybe about the fact that there's NGOs, so there's non-governmental organisations that can put a lot of pressure and have a say in, so there's no longer states who are the only ones kind of making this international law.
In a sense, we don't have studies because social science was not that advanced in the past, but in a sense, maybe there were lobbies and individuals behind governments for trade, etc., etc. So in a sense, this is not very novel. Okay. Other points. Erga omnes and jus cogens were created because of human rights. This brings a hierarchy. International was already a horizontal system. It is increasingly becoming a vertical system. Why? Because of human rights. Enforcement, collective enforcement in the law, state responsibility. This did not exist before human rights. There was no need for that. Because of human rights, all states, even if they are not injured, Article 48 of the ILC norms, they may invoke the responsibility of another state. I will not go through, we will have a seminar devoted to that, but what I want you to understand at this preliminary level is that human rights originally was constitutional, was domestic. Because of World War II, this became international law. How? Through the traditional means of international law. Another point, you have this discussion about whether custom should be followed in the case of human rights. You have scholars who say, well, human rights is a different area, we cannot rely on state practice, we need something different. This is changing the ways the law is made because of human rights. Okay? So, the first point is that these were two different things. And the second point is that now there is an interaction between those two. International human rights protection is hybrid in the sense that it contains both elements. There are judgments before international courts that you read them and you say, well, this is not international law. This is simply enough constitutional law. You could have exactly the same case before the Constitutional Court of South Africa, before the Supreme Court of the United States, or before the German Federal Constitutional Court. The judgments I'm giving you next week to read are such judgments. They're merely constitutional. What changes is that instead of being at this level, you went at this level, international. But the substance, what is at stake, the way the law functions, is identical to domestic law. But then, there are aspects of international human rights protection that are international. And this is why you need, in a sense, to be in a position to make use of both legal systems. Okay? And this is why I'm insisting that you have a prior knowledge on international law. This was the first main point I wanted us to discuss today. Any questions on that? Clear? Okay. Second point. Before that, any preferences? Is there here anyone who feels more of an international lawyer or someone who feels more of a constitutional lawyer? What I have in mind is I will give you two questions to choose one. One will be more international oriented and the other one will be more human rights focused and constitutional, so substantive constitutional dimension of human rights. So that I can cover both groups.
So do you mean by human rights, you focus on the individual or focus on international law? Is that what you're saying?
No, I'm saying that there will be two questions. One will require you to reflect on human rights and their interaction with international law from the perspective of international law. And there will be another question that will be mainly focusing on the function of human rights as constitutional rights. Okay? So this was the first point. Moving to the second point. You told me that they are natural, that they are universal, inalienable, some other fancy terms. Can I collect? Are they?
No. They should be. They're supposed to be.
Why they're supposed to be?
Because the idea of human rights that people see is that no matter who you are or where you're from or how much or whatever, you are deserving of those rights.
Okay. Yes. You're from the UK. How do you greet people when you see someone?
Hello, how are you?
Hello, how are you? Do you touch each other?
Not really.
Not really. The Latin Americans, do you
Yeah.
talk? In Greece too, we hug each other, we kiss. Japan, how do you greet people? Like, Isn't it? Yeah, like that. Yeah. 3 different cultures, 3 different ways to interact, 3 different understandings of what is wrong and right.
Yeah.
If next time I see you, you're a woman, I wouldn't do that, don't want to go for sexual harassment. You're British, aren't you? If next time I see you, it's, the Greek way, not, but I hug you, hello Mar, how are you, let me, would you feel like, yes. Would that be right for you or wrong, my conduct?
I'd forgive you for it, it's fine.
You would forgive me, but you would say, well, this is not the right way to greet people.
Yeah, but socially it would be a bit like...
Okay, and then you want to tell me that within this multicultural, where diversity prevails world, with different values, we all have the same understanding about what is right or wrong?
No.
Human rights are associated with values. They are fundamental, as we call them, although this is not a very accurate legal term in the sense we don't know what is fundamental, what is not fundamental. But they are fundamental. Why? Because they are essential for the human being. Okay? And they are often associated with principles. This is the 3rd point we will see today. Liberty, freedom, dignity, etc. Okay? Do they mean the same thing? Does liberty mean the same thing to everyone? Does dignity mean the same thing to everyone? If you take an ultra-conservative religious person and a libertarian person, will they tell you that liberty is the same? No. On the other hand, don't we all feel pain if someone tortures us?
Yeah.
Is there something which is universally accepted to be wrong? Yes or no?
Yeah.
What do you think?
Some things are not cultural, are human, really. Pain and
How does this translate into universality of human rights?
Well, you don't have a right to impose your values on, so that's like a base level kind of, and you don't have a right to tell someone else how they should live their life. And I don't know.
If you live by yourself, maybe. But if we live in a society, you will impose something on me and I will impose something on you. If my values is public nudity, there has been a case before the European Court on that. Okay, so the Rambler, maybe you know he's a British guy, Rambler something. So there is a guy who says, for me, wearing clothes is immoral. I want to go everywhere being nude. This is my freedom. And then you're telling me it is not right that you impose your values on me. Well, next time I'll come here and I'll come here and I'll be naked. Would that be acceptable? Would that be? Living in a society means that we interact. Your rights are my duties and vice versa. What is good for me might be bad for you. And we have conflicts. Conflicts of values, but also conflicts of interests. If this is my property, and you think, well, this should become a public school or a hospital for the benefit of everyone, this is general interest or your interest versus my interest. Human rights are in a sense tragical, in the ancient Greek meaning of the term. You have two right things that they are clashing. And we will see in the seminars that follow, including the very next seminar, how this works, how this functions. Human rights are not always straightforward ideas like the state, the bad state should not kill people. It does it for a reason. It does it because you're a terrorist and I need to protect the society from you. So human rights also very often translate into a clash not only of values but also of interests between members of the society. And we are asked to make in our everyday lives very sensitive balancing, and to take moral decisions which are in a sense tragical. So, human rights are associated with morality. Morality, to my understanding, is subjective. You have other people who say that morality is something which is objective. But this is, a huge philosophical dichotomy. It goes, deep into moral philosophy. It goes deep. It is outside law. In law, we are simply not translating moral dilemmas that philosophers have been struggling for ages to deal with. Okay? Can I ask you here? So the point I want to make. Let me become a bit more provocative. There is no right or wrong answer. Okay? Politically provocative. First of all, let me start with the British. Should prisoners vote?
I think so.
You think so?
I don't think so.
You don't think so? You don't think so? Okay. Should women be allowed to have an abortion? Yes or no?
I'm against abortion, but I think it's the woman's right to make that choice.
Okay. Against it, but you priority given to
I'm
liberty.
against it, morally,
Yeah.
but I'm not going to outrule it.
Okay. Against, in favor? Can I ask you just to raise your hands? Who is in favor of abortions? Some murderers over there. Who is against it? Some ultra-conservative people. Yeah. Just to give you a hint, there has been a study in the United States showing that our approach to that question of judges would change depending on whether they had a daughter or not. If a judge would have a daughter, would tend to be more open-minded and allow abortion, etc. Why? Because he was living with that person, they may have faced that problem in their house. Whereas people who did not have daughters, they were, morality, integrity, or whatever. Another example that this is subjective and it changes on the basis of the experiences we have in our lives. Okay? Yeah. Next question. Who is in favor of death penalty? Death penalty, capital penalty.
Okay.
All of you against it? Sometimes. When?
Murder.
Murder, okay?
I'm not against it because I think that this sounds quite bad, but the person who's committed the crime, say murder or whatever, doesn't deserve to be killed. I'm against it because I just don't think it's a suitable punishment.
Okay. So they deserve, but it's not fit for purpose. Okay.
For me, it's the issue of, you can't ever definitively prove. Well, sometimes you can, but most of the time there is some doubt.
Okay.
Some balance of probability.
So sometimes we should kill, some of you say. Shall we torture sometimes? Yes? No?
I think it's what people's definition of what torture is. Isn't it?
I mean, this is another good point, how we define standards. We might deal with that question in the seminars, not sure 100%. But for the purposes of the question here, imagine, typical Hollywood torturing, like the knives and killing and, the... Shall we torture? Does anyone here have a child, a kid?
A little brother.
Huh?
A little brother.
A little brother, okay. If you knew that someone has kidnapped your daughter, is it daughter or son? Daughter. And they are about to do extremely bad things. And they are arrested by the police, but they don't reveal where she is. Would you accept them? Would you accept torture as a means to
I
retrieve
know it
information?
doesn't work.
Hmm?
I know it doesn't work.
If you knew you would work, if I provide you evidence that it works.
No.
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 Okay. A man of principle.
But then isn't that why we turn to human rights, and it says that there are only sort of, for example, 4 rights that cannot be derogated against. So if you're a human being,
Wait for the next seminar. They can't. They can't. Just wait for the next seminar. The point I'm trying to make here is that at an abstract level, we are all in favor of human life. Yes, it is sacred, it is natural, it is whatever. But then in our everyday life, as we interact in a society as human beings, and as we all have different perceptions, ideals, morality, ideology, etc., we give different answers to different questions. Okay? Yes, in principle we should respect life, but abortion is something different that maybe we can allow it. But not capital sentence because it doesn't work. Or yes, in some exceptional cases, murderers maybe we should. Why? To punish them and make them, deter other people from doing this, etc., etc. There is a lot of debate about what is right and what is wrong, which allows me to make 2 points that I want you to keep in mind. The first point has to do with this seminar, the second one is a legal question. The point to make is that there is a lot of debate about political correctness and about, Here, I want us to discuss freely, there is no right or wrong. Even if you're the most conservative or the most liberal person, etc., let's discuss it first. And the second point is that behind the law, behind technicalities, behind the way we interpret and we say that the right is absolute or it can be derogated, etc., etc., it is ideology. Okay? The second point I want to make. These examples allow us to understand why it is so difficult to answer the question of what makes human rights law. In the old good times, before positivism, we had the idea of naturalism. Okay? Rights are given by God. Rights are given, Kant says, by morality. But then you have postmodern approaches that say, there is no one single morality, there is no one box that fits everyone. And this translates into other fundamental questions for law that apply both here, but also here. Should human rights be created by majorities? Or they are there irrespective of what the majority wants?
I think they should be that irrespective.
Irrespective of what the majority. What do you think, the rest of you?
Well, the rights come from norms.
Hmm?
The rights come from norms anyway, so the majority would say, well, this is what we're used to, and the rights will develop that way.
But if the majority goes against human rights, could that be acceptable?
It depends on the right. I mean, it's the right to life. For
Mm-hmm.
example, then you have to say that the majority is wrong.
Okay. Which?
On the big cases,
Mm-hmm. Can you think of any? Can you think?
There's rights.
Can you think of any cases where clearly it should be the majority that decides?
Well, it should be the majority that decides. Well, I don't know any cases that after. I mean, if you're talking about the government's decided, the citizens are saying, well, it's a grey area. We just mentioned prisoners' rights. The government has decided and hasn't asked anyone else.
Okay.
The government is acting on the supposed majority.
Yes. I'll come back to that. Anyone else?
In the development of human rights, if the Universal Declaration of Human Rights was passed as a UNGA resolution, wasn't it the consensus of the majority that they voted these particular
Mm-hmm. And this translates into state will. In human rights, should human rights be an issue of state will? Should it be what governments want? Or human rights exist irrespective of state will? If you go with the latter, then human rights should apply beyond treaties and customs should be something different than what we learned in the first semester. In domestic law, is it parliaments or judges? Shall we allow judges to set standards of human rights protection, or should always go to parliament? But if it goes to a parliament, then can we allow, I don't know, a majority of 200 white rich men deciding about the women's right?
My local MP's pro-torture. Through his own.
Kill him. Yeah.
So no to Parliament, but to judges, you know, you get different judges. You get activist judges, which is the problem with the EC. We work in court now. The British don't, British government don't like the activist responses.
So just to finish with this, two conclusive points. The first one is that you had we discussed this also in the first semester. Naturalism, positivism. Naturalism says that the law is God-given, etc., etc. Okay? Yeah, if you're very religious, this might be the case, but in that case, you might find yourself in conflict with positive law. Positive law means that the law is posited, it is constructed. How? By the institutions and the means and through the channels that we have established, sources, etc., in a given legal system. When it comes to human rights, we have a huge question mark. How are human rights created? Yes, sometimes they are created because of parliaments. Some others times because of a referendum. For instance, in Ireland they had a referendum on abortions. Okay? And then on gay marriage. Sometimes it is because judges say, well, this is the standard. Why? Because it derives from human dignity, because it is incompatible with the fundamental values and principles and etc. We go back to naturalism. Okay? But if you ask me, what makes human rights law valid law in the sense of positivism? What is the ideal way to create rules on human rights, both in domestic law and at the international level? I will tell you, I don't have an answer. I don't know what is the right way. If we should rely on principles and naturalism, going back to the principles is a hidden way to bring naturalism, into the system. If it should be aristocracy and some judges because of values, etc., because human rights are natural and inalienable and all that kind of ideas, or whether they should depend on the will of states, the will of governments, or majorities in the parliament. No answer. But, and this is the second point, there is definitely one thing that I'm personally certain about. Human rights change. 20 years ago, there were no gay rights in the West, not even in the West. Okay? 40 years ago, gay people were imprisoned in this country. Now there is a right to marriage and adoption. Is this across the West? No. Some countries are more conservative, some others no. Women's rights. Women did not have the right to vote just a few decades ago. There are still legal systems that perceive women as being at an inferior rank compared to men. So either you approach human rights as something which is constructed by the society, and then we say that this changes, because in terms of positive law, 100 years ago, women did not have the right to vote, but now they have the right to vote, and it is a fundamental human right. Why? Because somehow this has been posited, this has been created. Or you claim that human rights are natural law, and that simply enough, irrespective of what positive law says, what parliaments create as rules, etc., they are against human rights and they shouldn't exist. So in a sense, it is limiting the power of our institutions to posit the law, to create the law. Okay? After all, this is a meta-legal, or before the technicalities we will discuss here, question, and it is again a question of ideology. You will decide how much naturalist and universalist, or how much positivist and fragmentary in your approach to human rights you want to be. Okay? And to make it even more challenging for you, I will tell you that most of the times people are not consistent in between these two strands. If you go and take an interview from a judge and you ask them why you have chosen this, because the law says. And then you ask them, okay, would you, if the law would say that abortion is not good, would you go with that law? No, why? Because this is against my principles. Sometimes we stick with the law, sometimes we say, no, this is fundamentally against what I believe. And there is no right or wrong. There has never been right or wrong. Nietzsche said, let's leave it outside this room. Very briefly, third point. So, the first thing I want you to remember from today is that human rights originally started as domestic law and they have been transformed into the international law, and that area of law contains both elements, international and constitutional. The second point is that the foundations of human rights, if it is morality, if it is because these have been created, how they will be created by the society, if this change over time, what is right or wrong is subjective. I don't have an answer, and if anyone tells you that they have an answer, they are lying to you. They are either priests or bad lawyers, okay? Have I told you, do you know Cansado Trindade? Have you, Latin Americans, have you ever heard of him? Cansado Trindade, Antonio? You should all, who took this first semester seminar, this is a judge now at the ACJ, okay?
I think he's Brazilian.
He's a Brazilian judge at the ACJ. I've met with him, lovely person, and his wife, absolutely live. He's kind of neo-naturalist in his approach to human rights and very pro-human rights and against sovereignty. But if you discuss with him, you know, why? Because it is right. Why it is right? Because it is right. And I remember him in the Hague Academy. I was attending his classes. It's very prestigious to be invited to give a class at the Hague Academy. He was like a priest. He was like, the voluntarist positivists, do not believe them. They are lying to you. No, you are lying to us.
But I think he's, in Brazil it's like that.
No, it is his style also. He's he's a fantastic guy, but very naturalist.
No, but yeah.
So my point, the second point is question mark. So everything goes, everything is acceptable, let's debate it. And in the end, there is no right or wrong answer. Okay? If you want, this goes back to the fundamental foundations of liberal democracies. Liberal democracies mean that we should focus on liberty, freedom, and decide on a democratic way. Is this applicable in the case of human rights? Majority rule? What are the limits of the majority rule? So these are the limits. We go through human rights, we touch the inner foundations of, and these are political questions of political philosophy, of what are the limits, who decides, and when they decide, how they decide about these issues. Third point. I've already told you that human rights are related with principles. We'll see that again in more detail in the seminars to come. But, can someone remind me how the French flag looks like?
French flag.
French flag. I don't expect British people to know that, but...
Blue, white and red, is it?
Yeah?
Blue on the top, white in the middle, red on the bottom.
Yeah, 3 colors.
3 colors, yes.
Liberté and blue, white.
So the French flag, which was created after the French Revolution, going back to Enlightenment, etc., has 3 stripes, and these 3 stripes stand for liberty, equality, and solidarity or fraternité, brotherhood. Can you link this with human rights? If I would ask you to give me human rights and classify, if I would tell you that these are 3 different types of human rights, can you give me rights and tell me in which group I should put them?
Freedom of religion and liberty.
Religion.
The
Yeah.
right to equal protection of the law, irrespective of your religion, gender.
Non-discrimination.
Equality.
Let's leave this aside because this is the most problematic one. Why some people would say that this is overarching. It applies to all 3 of them. Some other would put it here, I would put it here. But let's leave this, let's go with the easy ones. Other ones.
Workers' rights and solidarity. Workers' rights and solidarity.
Workers' rights. Can you be more specific? Workers' rights is a family of rights.
I'm trying to remember what there was the lawyers that were coming out in 1789 that were after something very specific, and it's just escaping me at the moment.
Prohibition of slavery.
Politics.
Slavery, I'll come back to you. Where would you put it?
I don't know.
Is the matter of equality? Is the matter of liberty? Free from being tortured, okay? Torture. What did you say?
Politics.
Eh?
Politics. Selection.
Poverty. Poverty is a situation, okay? It's a social phenomenon. How would you translate this into human rights?
Translate. I don't know.
I'd say like food and water and equality.
Freedom of water. If it is freedom of water, it will be liberty.
Food and water.
Food and water. I would put it.
Solidarity.
I would put it here.
Right to life.
Food, water, life. Or would you put it?
Equality, liberty.
Equality or liberty.
Equality, actually.
Liberty.
There's like a very big debate with that, isn't it? Because life could be
Not at all. Life is primarily right to life means you have the right to live, means that I don't kill you. I don't have the right to kill you. Okay? Other ones?
The right to self-determination could go under solidarity.
Jen, you're going after the difficult ones. Self-determination is the right to become a state. For some people, including myself, it is not even a human right. Okay?
Right to a fair trial and equality.
Equality. Equality or freedom?
Fair trial just before the time.
What does it mean, equality?
Same as everything.
That we all be at the same level. This is just to have a fair trial, not to be, that it is an impartial court, etc., etc. It's not that you are at the same level as someone else. And of course, we are all entitled to have the same rights, okay? But this is equality in this context means something different.
Should like maybe the right to vote and equality?
Right to vote, again here. What you're doing is that you are confusing that liberties should equally apply to all human beings. This is something different. Yes, if I have a freedom, you should have that freedom too. Equality means something different. That me and you, we should be equal. How can this be achieved? Welfare state, health, education, all these would go in that case. What is the fundamental difference between these 2 categories of rights and why we put them into different boxes?
What is economic?
Economic dimension. Who has an economic dimension?
Equality.
Very good point. Excellent point. Yes? Why they have an economic dimension?
To bring it one of the reasons for the riots for the revolution is because the country collapsed.
But why these rights here have an economic dimension today?
It depends on money.
They depend on money. Long story short, these are three different principles. They all, in the context of the French Revolution, were designed to perform in the system of the constitutional dimension that we discussed earlier, individuals versus state. With the first case, individuals are asking from the state not to do things. We could call this hands off. I want to be free. That means that you as a state, you should not interfere with my religion, you should not torture me, you should not kill me, you should not give me an impartial trial, you should not prevent me from expressing my political views and voting, etc. These are negative. The state should abstain from doing something. The only thing I want from the state is not to do something. Whereas here, these are the opposite, they are positive. And I expect the state not to abstain from doing something, but to give me, to provide. I want you to provide me food. I want you to provide me water. Of course, these are linked with life, but we will reconsider this approach in the next few seminars. I want you to give me education. Not everyone is equally rich, not everyone can afford going to school. You should spend money, as you said, in order to bring me at the same level with the others, so that we can all enjoy education, health, welfare state, etc. We will discuss this much more in detail in the seminars to come. And I will tell you, I will explain you that this picture is no more accurate. Okay? We have now a much more developed system that challenges this picture here, this scheme. But what I want you to tell you, and this goes back to the constitutional dimension of human rights, is that A, principles from which human rights derive are associated with the relationship between the individual and the state, and that we classify human rights on the basis of two big boxes. Solidarity, I'll give you in a minute a few examples, but let's leave it aside. One is the negative, and we want the state to abstain from doing things, and the other one is the positive, and we want the state to provide. This transforms into two big differences, two big classes, families of rights. Which one is the first one?
Negative.
No, yeah, negative and positive, liberty, equality. The other term you would use here, how do we call these rights?
First generation.
Yes, before that another term.
Civil and political.
These are civil and political rights. These are social rights. Social rights initially at the constitutional level, international law has changed this, we will see it, meant that the state needs to provide, and civil and political mean that the state should abstain. At the international level, there has been a huge debate and a huge clash between Western liberal economies versus socialist countries. The US and Europe, part of Europe, were giving a priority to this. So this is political freedom in a sense. Whereas socialist governments were giving a priority to it. And they were saying, no, we don't need this. What we want is to provide to people accommodation, job, food, water, etc., etc. Okay? So in international law, this translates into the generations, as you said. We had the first generation of rights. Why? because these were the first one to be recognized at the international level, to become internationalized. And the Universal Declaration mainly contains that category of rights. And then the second generation, with mainly the covenant, the UN Covenant on social, economic, and cultural rights, you had this second category. So, two different families: liberty, equality, negative, positive, civil and political, social and economic. No economic cost, they entail economic cost. First generation, second generation. Okay? Solidarity is, you have lots of scholars who will say it is something important, etc. I will be rather nihilist here, that will tell you it has no content, it is rights like a right to peace, right to brotherhood, let's live all together. It's like a mid-60s, this kind of cultural revolution that led to
To nowhere.
to nowhere. Yeah. So some people will tell you this has a content, I will tell you no. I think we have to leave this room. Can I just ask you to sign, just take a piece of paper and sign, write down your names so that I can know who was here today. I hope you found it interesting. There is reading for you for next week and we will continue. I will email you about the venue, okay?